Well, hello, friends. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. Wow, what a past 48 hours we've experienced in the EB-5 ecosystem. Very pleased to have with us our very esteemed pop-up guest, Ishaan Khanna, who is the president of American Immigrant Investor Alliance, AIIA, and a longtime advocate of EB-5 investors in our space. So Ishaan, welcome.
Thanks for having me.
And apologize to our guests, Aaron Grau, who was invited to speak and who had accepted, could not make it today.
I'm not as good looking as Aaron, but I'll try, you know.
Oh, I don't know about that. I'd rank you both kind of, in the same very high stratum. So Ishaan, let's unpack this. So we had a bit of a bombshell dropping happening late yesterday afternoon with President Trump announcing in the course of a press conference, I think out of the Oval Office, with the Commerce Secretary, informing the public that he is contemplating a gold visa with a $5 million price tag. And I think what has got the EB-5 community sort of juiced up and concerned is, well, what does this mean for EB-5? And specifically, does it mean that this will do away with or replace EB-5? So come in at any point in this, what are we to make of this?
Right. So I think the most significant thing that we should start with is that the fact that the current sitting president of the United States uttered the words EB-5 out of his mouth. Like, that is huge. Like, I don't think anyone has truly acknowledged that. Like, in the past you had, Biden, sure, he signed off on the RIA, and past administrations have been around when things happen, but for the first time, the president himself acknowledged EB-5. Like, the impact that this has just politically is huge. I mean, the lobbying playing field, what happens in 2027 with reauthorization? I mean, all those variables have now changed. And I think like the way that Congress members, that staffers, all of that will now respond when any of the members of the industry try and talk to them about this is going to be so vastly different than it was before. So I can tell you.
Break that down. And how? What do you mean by that?
Just because it's given the importance that it didn't have before. So you remember this in the last couple of months, we had seen Elon Musk and the whole H-1B issue that came up, right? Like, it was funny because people who have zero interest in US immigration are now suddenly experts on H-1B, right? If you're following all the Twitter drama and all that. And now that I think EB-5 is just beginning to get that same treatment. There are friends of mine who've known that, I do something in immigration, right? Like, normal civilian friends of mine who have no idea about EB-5. They see this in the mainstream news and they're like, hey, is this relevant to you? Like, right. Just
it's in the Wall Street Journal.
Instagram reel or whatever. Yeah, like for the first time, our industry, what we all do for work, and I see many, many people from the industry as attendees right now, of the 150 people on this call, like it is funny that our industry, the work we do has now just gone mainstream. So I think that takes a moment to acknowledge that, right? So that this is now in discussion. Look, Trump says a lot of things, right? Like, he said a lot of things that will never come to fruition, from making Canada the 51st state to giving green cards to college grads after they graduate, right? That's something he said before he became president. All of that, like, when we take all of that into account, I think we can all, sort of treat this as a nothing burger, right? That hey, this is just Trump saying that he wants to open up different pathways. He wants a golden, card and things like that. But I think the true ramifications of this will be in the long term. That'll be when the discussion of reauthorization comes up in 2026 and 2027, and what the Secretary of Commerce just said yesterday, that will come up in conversation. People will say that, hey, well, that Secretary Lutnick said that this program is full of fraud and is wasteful. I mean, it's that sort of conversation, I think, and that sort of dialogue is what we as members of the EB-5 industry will be dealing with. And I think that is far more important to focus on. In my opinion, and based on the conversations that we at the American Immigrant Investor Alliance have had with our lobbyists and our legal experts, in the short term, this means nothing. Truly, this is a nothing burger. We'll see what Trump has to say in 2 weeks. Let's not forget that just an hour and a half ago, he made another statement about EB-5. For those of you who haven't seen it, I mean, we'll drop the link or something.
Breaking news.
Yeah, we should talk about that. But in the short term, so just to sum up what I said, so in the short term, I don't expect any drastic changes. Let's see again what he says in 2 weeks' time. But in the long terms, this does change the playing field.
Well, that was super insightful, Ishaan. But and I do want to talk about the long-term effects and the reauthorization and the larger conversation there. So important. But let's kind of zoom back into what happened. I mean, and so much of this, right, is calibrating messages like this and information like this to the right level of concern or concern. Right? Is it a nothing burger on the one extreme, or is it, as many investors and clients and groups are worried about, is this something transformative that, we really do need to be concerned about, or are we somewhere in between? Because I gotta say, I don't quite read this as nothing burger. I have been having conversations, I feel like, since late yesterday afternoon, like, let's keep calm. Let's take in information. We don't have a lot of specifics. This was an informal expression, but at the same time, it is an expression of intention, right, by the president. And so I don't think. I mean, I'm not sure that we can just sort of write it off entirely.
I agree with you, and just to clarify, when I say nothing burger, I truly mean it in the short term, right? And I say this because I'm working with EB-5 investors on a daily basis. I mean, look, right now, right? If you take a look at your Q&A section on this webinar, there's already a couple of questions that have come in, and it's all from investors who are like, "Oh my God, what's going to happen to my petition? What's going to happen to my investment? Will I get my approval? Will I get my visa allocated to me if Trump shuts this down?" Right? For them, I say, guys, relax. This is fine. You'll be okay, right? Let's not forget. Like, I want to sort of bring it down to the history now. What happened in 2021? Why did me and the other investors who started AIIA, why did we do it? We pushed for the grandfathering language. We still have those grandfathering protections. Even if something changes tomorrow, you will be okay. The same rules at which you invested in will still apply. That won't apply to everything because we've also got a lawsuit going on. That's also there. But at least, yeah.
Well, first of all, I want to once again give a shout out to AIIA for its really important advocacy at those last stages of RIA advocacy and drafting. I think your group was really championing getting Section 106 in there, the grandfathering provision that's so important. So once again, thank you and congratulations for that effort, and let's do it again. That said, I mean, let's break this down. So I do concur with you at where you've pitched it. Nothing's going to happen tomorrow. Most likely, anything can happen. I think is that we in EB-5 know that better than anybody. But let's kind of break this down and walk this back. Now, the RIA and the immigration laws, generally speaking. So we're talking about the Immigration Nationality Act. This is a statute. The RIA is a part of the statute. Let's break this down for folks. So we have the law that's an act of Congress, and we have the executive who may want to reshape, change, do, make an imprint on an act of Congress. How does that work? I mean, can the executive unilaterally change the law? Let's impart that understanding to our folks. And I can speak to it as well, of course, but
yeah, I think you should definitely should. I mean, you're the one that went to law school, not me. But I will say that, as far as my knowledge goes and everything, everything that I've seen and heard and, been in this EB-5 political space as well, like it will require an act of Congress to change the EB-5 program. If people think that, all Trump needs to do is show up with a couple of executive orders and this program is suddenly going to change tomorrow, that's wrong. I don't think it's possible. And even if he did try to do something like that, the law is still in our favor. I mean, this is why litigation exists. I mean, this is why, even as a nonprofit, we're such big fans of, litigation. If, the law is very clear and this is still a, law-abiding country, if Trump does issue an executive order that goes against what the statute says, then we will challenge him on it and hopefully win.
So yeah, let us break that down, and I will play the lawyer at this moment. So the RIA, the EB-5 Reform and Integrity Act of 2022, which is a part of the Immigration Nationality Act, or the INA, these are acts of Congress. They're federal statutes. And under our system of government and the three branches and the separation of powers, lawmaking is the purview of Congress. It is the purview of the courts as the second of the third branches to interpret our laws. And it's the purview of the executive, the president, to execute our laws. So Ishaan is absolutely right. No executive can amend the statute. That's just not a constitutional power that he or she has. However, couple of important points. The agencies are under the purview of the executive, which includes USCIS, which is part of the Department of Homeland Security, as is the National Visa Center, consulates, which are under US Department of State. So these cabinet departments are organized under the executive. So in that, exercising that power, the president has significant influence and authority over how the agencies execute the laws. Okay. So how about amending the statute, right? So now we've established, okay, so as you said, Ishaan, no president can, with a whip of the pen or with an executive order, undo or change or repeal statute. But what about the prospect of amending the statute? I mean, could that happen in 2 weeks?
I think the answer is no, right? I mean, you'd still need sign off from members of Congress. I mean, what we think is, if I were the president and if I wanted to change the statute, I would likely wait until one of the next spending bills and use that leverage and negotiating power to sort of make that change happen. That's likely what I would do. To pass a bill just from scratch, putting it out there in the current Congress, there's just no way. I mean, there are a significant number of Republicans that are in favor of the EB-5 program. Right? I mean, they've written letters, they've given opinions on it. Take, for example, Senator Grassley, right? Like, he put a lot of airtime and effort into the RIA. Are you saying that we're just going to go back and, change his work? I don't see that happening in the current political landscape.
Right. Okay. So now let's pivot. So we've kind of played out, the could it happen? I think that was the question. Could it really happen? Could EB-5 be gone in 2 weeks? No. Well, again, it's possible that Congress can change the laws, but not likely. Now let's share some late breaking news. So the question, at least in my mind immediately, was, hey, are we talking about gold visa and EB-5? because that could be great. Or are we talking about gold visa in lieu of EB-5, right? So Ishaan, I think we have a little bit of color on that now, and very, very late breaking. Will you share that with us?
Sure. So about almost 2 hours ago, there's a video clip circulating on X right now about this. Trump came out and seems to be in a boardroom with his Commerce Secretary and a whole bunch of other people. He comes out and he says that essentially we are going to be modifying the EB-5 program. He did not say abolish. He didn't say we're going to get rid of it. There's a little bit of a pivot from what he said yesterday. He said we're going to modify the program. And then he went on to talk about the investment amount and $5 million and things like that. And then there was something else that was really distinct that came from, I believe, the secretary, who said, we will do this under the Department of Commerce. See, now, EB-5 is an immigration program. It's always been, for decades, under USCIS. We're changing it to make it a commerce program now. This changes the dynamics so much, that from adjudication to the people in charge of it, all of that suddenly like changes. So again, there's no hard proposal in front of us. I guess what makes me nervous about all of this, see, look, I raise EB-5 money, right? I mean, I raise money for everything from, boutique hotels in New York to nightclubs in Miami to, ski resorts in Montana, to multifamily housing in Colorado. Like, when these real estate developers are planning for the future, when they're, trying to anticipate, what kind of financing I will need, how much I will need, can I go get it from EB-5, which country will I go to, all of that. Now suddenly, the developer's not able to plan or figure this out. Do I need to start planning for $5 million ticket sizes? Will I even get that same level of demand? I mean, just from a project perspective now, this throws so many unknowns into it. I think the work that you and I do is a little bit more investor facing, right? Because we're dealing with these individual immigrant investors, and and if the price point changes, maybe there's a different personality of investors coming through. But now the question becomes is, what about the developers and the project sponsors who actually need to plan ahead for their financing needs? And this really sort of throws up a lot of unknowns, which I think the industry will take a lot of time to adjust to if and when these changes actually happen.
You know what? I think that's absolutely right. I mean, immigration, so many uncertainties generally, right? And then one would say, particularly in EB-5, it's very, very dynamic, fast changing. It's very unpredictable. I mean, it's an at-risk investment program after all, and true to that concept. But so there are all those sort of built-in uncertainties. From a developer standpoint, I mean, you always have the unknown of, the success of the capital raise, right? So you do have that, but I think the fundamental question, the more at first, when this broke, I was like, oh my gosh, not, like another thing that we've got to, it's another huge, uncertain little maelstrom in our world. But the more I think about this and unpack it, I think there's clarity. So that's positive. The more you analyze and look at and really study a situation, there is clarity that emerges. Isn't it really the question that we really have is, I mean, are we doing away with EB-5? And I think we're getting close to concluding, no, we're not doing away with EB-5. I mean, that's how things, I think that is pretty clear today. Or, I mean, that's, I think, the predominant conclusion that I feel comfortable with today.
Wasn't it clear yesterday as well?
Yeah, exactly. And I think part of this close study is we really want to closely study the words, because I don't believe the president said we're going to replace EB-5. The Commerce Secretary did.
That's right. Yeah.
Yeah. So I think what's being disseminated today is actually consistent with the president's message from yesterday. So I think the close, the close parsing does help bring clarity. And I think that the one question was, is EB-5 going away? And I think that's the question that we want to focus on. And if it's not going away, well, the president always has the authority to reshape and issue policy around immigration programs and agency operations in every administration. So that's not new. But I don't want to underplay the fact that, like, to your point, there is a signaling here. There's a signaling that there's going to be stuff happening in EB-5. And I think that is very significant.
Exactly. And that's what I keep sort of coming back to, which is how we started this conversation, which is I believe the long-term impact on this from a political perspective, from a legislative lobbying perspective, that is what has really altered. Again, in the short term, and again, I'm looking at all these questions which are coming in from different folks. People are worried about things like the processing times and, what will happen in 2 weeks and all that. And again, I would push the narrative that don't worry. There is the one legitimate concern that people have is that, will Trump slow down the processing of the existing petitions in line, right? That is a legitimate concern. He did that before, back in the 2016, 2017, 2018. And we already know that certain IPO staff has been let go and people at USCIS have been let go. So there's already staffing shortages, which are beginning. I hope that does not happen. I hope that processing does not slow down. I think we as an industry have really benefited from having quicker approvals. Investors have preferred, putting in their hard-earned money and getting their green card quicker than when people did back in, say, 2019 onwards. So we hope that doesn't change. And if it does change, again, I would remind people that America is a litigious country. I'm a big fan of suing the government. I mean, I personally sued the USCIS to get my approval faster. AIIA has 5 separate lawsuits open against USCIS. We will sue the USCIS if there is a negative impact towards the processing of investor petitions, and individual investors will as well. But that's, again, this is what I would say between now and 2027 would sort of be the bigger concern. Obviously, I hope that I won't be wrong. I hope in 2 weeks that there isn't some sort of drastic change, but this is what I feel is more likely to happen than not.
So let's now pivot. To looking ahead to the next 2 years. So the EB-5 Regional Center program will sunset again, which is like the 30th, September 30, 2027. And again, thanks to AIIA and the other advocates, including AIIA and others, we have the grandfathering provisions in Section 106. So let's assume no legislative changes. Let's do that. I mean, just know that could happen, but let's assume no legislative changes and we have the RIA intact. Let's walk through the grandfathering provision and what that means and the protections it affords. And I think that's a whole separate webinar. There's a lot to unpack there, but let's start with some broad strokes. Talk about grandfathering.
Sure. So look, the way to explain it sort of simply is that if you as an EB-5 investor invest today, well, if you've already invested all the way till if you invest until the end of September 2026, I'll repeat that again, until September 2026, when the grandfathering provision expires. If you invest before that time, or if you have invested before that time, your investment amount, the rules at which you have invested by, they should remain the same. Your processing of the adjudication of a petition, all of that should happen just as, according to the promise that the government has essentially, gotten into with you. So after that, if you were to invest after September 2026, and if in 2027 the program is not reauthorized, then your petition, your immigrant petition, can be in jeopardy. Because just like in 2021, when the program lapsed, all those investors who had not received their conditional green cards yet had their immigration process stalled. That is what I think almost everyone is fearful of. Nobody wants to, no regional center, I would hope, wants to take the hard-earned investors' money and not, be in a situation where the investor doesn't get their green card or their petition is no longer being adjudicated, right? So that is the importance of grandfathering. It protects investors regardless of how the program changes in the future, or if the program was to go away completely. So that is important. If you're an investor who invests, say, at the end of 2026, it's December 2026, you make your investment, but in 2027, this program does not get reauthorized because, let's just say, this industry is not united, or that the Commerce Secretary repeats his claims again, that the program is not good, and the program just doesn't get reauthorized, then those investors would be in jeopardy. And that would not be good.
Yeah. So that's very, very important, this grandfathering provision. And I just want to add to that, and then we can either pause and take some questions related to this discussion or move on to some other topics. The grandfathering idea is really about, it's a due process concept. You engage in conduct like making a significant investment in reliance on the rules in place at that time. You can do no other, right? You can't take action based on some speculative future development. You've got to comply with the laws in place at the time you file. And so the idea is, well, those are the laws that must govern that case when it's adjudicated, and it should be adjudicated. It's sort of a core due process concept. And so we have that, and let us hope that that section in particular remains intact, and moreover is given effect in the fullest breadth intended. And we, the advocates, will be very closely monitoring that.
Yeah. I will say that I would hope for especially the industry stakeholders that are watching this webinar and will watch this recording and stuff, is that now more than ever, it is important for all stakeholders to come together. It is critical. If we are not on a united front, if we're not putting our best foot forward as an industry, that we are offering a fair deal to investors, that we are financing projects that are truly impactful in a positive way to the local economy, if we are not all on the same page on that, we will likely not get reauthorization. We have to recognize that as of yesterday and with today's conversation, that the cards are stacked against us. And that is the truth. There were critical things said about our program. Now, we can all make great PR statements and say, look, we welcome the opportunity for us to work together and collaborate, but let's face the facts. There's been something negative said about this industry. It has put the immigrants that we work with in a state of fear. We have to work together. We should work together, especially in 2026 and as we get closer towards 2027, to work together as a united front. And of course, look, it's hard to be on a united front when different stakeholders are pitted against each other. When like let's take for example this lawsuit, which we should hear about the result this Thursday, or we may get another extension on that from USCIS. With this lawsuit that has taken place in the sustainment period, it's pitted the EB-5 regional centers, this collective of regional centers, against the collective of EB-5 investors, the post-AIIA EB-5 investors. That can't keep going on. If we do that, you're going to have dissenting voices. You'll have, if a member of the press goes out and interviews 5 or 6 people, here's one perspective from a certain group, but here's a completely different perspective from someone else that says, oh no, hate this program, I can't get my money back, I'm working with people who are working against my interests. That's not going to help us. We have to think about things from a long-term perspective.
I want to just add to that, Ishaan, because that's very well stated. And in my own experience with advocacy on the Hill, what we would hear again and again is you can't ask us as members of Congress to go into the hornet's nest of immigration unless we know that your stakeholders are together. Now, I think it's important also to say, it doesn't mean we agree on everything, right? And we never will. And I think it's a sign of a mature, healthy, vibrant industry and stakeholder community to have conversations. So it's not that, but I think on the point of talking about the benefits, the real good stuff. And I don't think we need to rely on the fluff. I mean, the reality is that the program is bringing billions of dollars to the United States in rural and urban communities, in particular rural communities. So Senator Grassley and Senator Leahy's vision has been realized. It has redirected EB-5 capital to the rural areas in a way that it's never done before. And it's creating jobs and it's helping keep our economy robust. So, and it's helping immigrant investors realize their great American dream. So, I think these are the things that we can all rally around. I mean, it feels good to say. So, it's these points, right, Ishaan, that we're talking about, where we've got to be unified.
Yeah, exactly. I mean, like the hope is, or my hope is that, in 2026, there's not just, the developer from New York State that's talking about how his project has gotten built thanks to EB-5, but it's also the immigrant doctor from Virginia talking about how he's so happy to invest in an asset in a rural area and see a community, flourish thanks to his investment. There has to be a symbiotic relationship between the investment issuers, the developers, the other stakeholders, like everyone from the attorneys, business plan writers, all the way to the very core of what makes EB-5 program tick, which is the EB-5 investor. So that's what I would probably want to wrap up my statements at.
Well said. All right. So what should we do? We have a lot of questions. I feel like we should pause and take some questions. What do you think?
Yeah, sounds good.
All right,
Can
let's do
we
it.
start with Suzanne's? Because I know she's got some of the
Absolutely. I want you to
hard-hitting
MC
ones.
why don't you MC the questions?
Sure, okay.
Together.
So they're all for you, by the way, because they're very technical and law-based, but I think they're extremely relevant. So even those of you who don't understand what Suzanne is saying, like, you should listen to the answers because it's relevant to you. So I'll start from the very last one that she said, which is regarding the grandfathering provision. She says, it may be doubtful that we will have an extension by September 30th, 2026. If we don't have an extension by then, why would any investor invest post September 30th? The grandfathering provision should have existed until 2027.
100%.
Yeah, I guess, we all agree. I will say my theory, and I don't think anyone really knows what happened behind closed doors, but my theory is the reason why it expires on that date is to cause anxiety with the EB-5 community. Because I think if issuers and lawyers were to say, hey guys, come invest with us on October 1st, 2026, we're going to feel very nervous, because if that program does not reauthorize, or if the grandfathering provision is not extended, we're selling snake oil. No one wants to be a snake oil salesman.
No. And I think that, I mean, the positive spin on this, right, is yes, absolutely, it should have been coterminous with the expiration of the statute. However, I mean, it's a call to action, right? I mean, like no other. We've got to get this done before September 30, 2026. And what I mean is reauth. And permanent, right? The anxiety, the extreme anxiety in our system, it would be less, far, far less. There would be program improvements all around. We could invest, full-throatedly into adjudications, other infrastructure supporting this program if it were permanent. So we got to get it done.
Right. So another question Suzanne asked, which I don't think either of us might have the answer to this, but could a statutory change be slipped into the current budget reconciliation process? I would imagine yes, right? I mean,
yes, in theory, that's how certain bits of legislation can be slipped in. However, there are sort of, general principles about imposing limits on how much of that you can do. And so, hopefully we don't see that affecting EB-5. I mean, if you want to slip in the gold visa in there for 5 million and EB-5 is not touched, by all means, so yeah.
All right. And then the other part is, and the other question she asks is, does the executive have the power to shortly move EB-5 administration from USCIS to Department of Commerce, as the secretary said today?
Well, the RIA, we'd have to go back and look closely at the sections in the RIA that commits authority to the Secretary of Homeland Security. And then there are very specific provisions that are carved out to other departments. Like I think there is a reference to the Commerce Department with respect to the adjustments that are indexed, the investment threshold adjustments. So, I think that would imply that the rest of it is squarely in the purview of the Department of Homeland Security Secretary. So, we'll have to see. I mean, there are there's a lot of, kind of testing of the boundaries of the separation of powers, right? And so we have to see what actually emerges as a matter of fact. Is that what's happening? What will happen? We can't say today, because that would be speculation.
Yeah. Maybe we should have Sam Odani on, because he made a point saying that, to answer our previous question, that it can't be slipped into reconciliation because it's against the rules. Mm-hmm. So that's good to know, right? I mean, that means there's another protection there for the changes to the program happening. So yeah. I think that's a good thing. But yeah, I think that's that. I don't know. There's another question that speaks to you. There's a lot from investors, of course. Mm-hmm. Okay, this is interesting. So in your opinion, if a new 5 million gold card were to replace the existing EB-5 visa program through congressional approval, would the total number of visa applicants significantly decrease because of the now increased investment amount?
I would say yes, without question. I mean, we can observe the difference between 500 to 800. And it's sort of, it feels axiomatic, right? I mean, we're just talking about an even more rarefied stratum of worldwide wealth. And just, it's by definition, we're talking about a smaller subset of worldwide population. So yes, I mean, but that said, we have 7 billion people. So, I mean, is there in theory demand for 1 million? Maybe. And I think, the benefits would have to call those global citizens out from the woodwork, right? And they would have to make the decision, yes, we want to stake a place in the United States for this threshold. So there are many questions there that we can't know right now.
Yeah, I would echo what you said. The other part that, especially given in today's news context, that I would want the public as well as news media to also just reflect upon is that, if we are talking about investment amount at $5 million. Now, I'm from India. It's a democracy. It's a capitalist country. It works slightly differently. But those countries that utilize EB-5, let's take China, for example, right? The number one popular market for EB-5. If you've got $5 million and you're Chinese from China, if you've got $5 million to invest in the US, chances are that you've gotten permission to have that kind of money. And I would say the same thing for the Russians too. I mean, we had a whole discussion. Trump talked about Russian oligarchs in his statement. Again, a Russian oligarch means someone who's had a sign off from the higher ups in his country to have that kind of wealth. So when it comes to the type of people that are going to be utilizing this new $5 million investment program, I think we should reflect on those individuals that will be able to do that. sort of leave it at that. But yeah, there's a lot of questions about the AIIA sustainment lawsuit if you want to take that on.
Should we pivot to that a bit? Yeah, let's hit it, because I think that is the other topic that's very foremost on people's minds. Probably was the most foremost before yesterday. So let's talk about that a little bit. So Ishaan, why don't you debrief us on just the state of play? Where are we with the litigation? And just kind of set it up too. Let's assume there are some folks joining who may not know too much about it.
Sure. So let's give a basic overview, right? So I mean, we can go back as far back as pre-RIA for this conversation, but essentially, one of the rules about EB-5 is that you have to sustain your investment for a certain period of time. Now, before the RIA came into place in March 22, the rules were that the investor must keep their investment sustained until the end of their conditional green card period. Now, USCIS actually admitted that when they came up with this rule, they did not anticipate the huge backlogs that people would get into. So imagine if, say, you're an investor from China or from India and you invested in the late 2020s, even if you get your approval, and even if the project that you've invested in completes and is in a position to repay you, you will not be able to get your money back because you've not finished your 2 years of conditional green card. That may be because of visa backlogs. It could be because of delayed processing on behalf of USCIS. It could be for a variety of reasons. And if your project is in a position to repay you as an investor, but you are not able to be repaid, your money then becomes redeployed or reinvested. This essentially means that even though you've done the due diligence on your first project that you've invested in, your money now is going to another project. Oftentimes, those investors have very little say or control over where this money goes. Now, this has been a redeployment. The act of redeployment is something that I have been vehemently against, and I've talked about it for years. And in fact, our lobbyists even lobbied to end the practice back when the RIA was being negotiated. Nevertheless, the RIA passed and it changed the rules. So the law changed. I should be very clear on that. The law changed to now simply state that the investor must keep their money sustained for 2 years. However, what the law did not do was define what the start date of the 2 years was. So USCIS came up with a rule and said, well, now that the law has changed and it's no longer tied to the sustainment, the 2-year sustainment period is no longer tied to the conditional green card period, we must now define when this 2-year period starts. And so USCIS, which I think they did correctly, they said, all right, we will start the 2-year clock from the day the investor's last dollar enters the project. Pretty simple. Great. Now, this is the minimum 2-year period. It does not a ceiling. It's not a maximum. It simply says, hey, we will approve your petition as long as you kept your money invested for a minimum of 2 years. Now, whether your project was a 3-year project, a 7-year project, that's up to you. You choose. That's the free market. And that is a rule that USCIS established. Certain people in the industry did not like that. They sued USCIS and they pushed USCIS just to essentially go through notice and comment. They pushed, their argument was that yes, the law has changed, but this 2 years period, statement period, did not come with a defined start date. You cannot just arbitrarily define either when the 2-year period starts. And so they sued, they've been successful. My organization, the Investor Nonprofit, we have been against this. We believe a 2-year minimum is better because it prevents investors' money from being redeployed. The investors are free to choose what length of time they can choose their investment for. And so now what has happened is that the lawsuit has gone in the industry coalition's favor. And this Thursday, we will hear about what that final settlement comes down to. We may also get an extension. My organization, we have filed an amicus brief, a friend of the court, in favor of the government against the EB-5 regional centers. I don't know if it actually helped move the needle or not, but that's been our position. We, as an organization, are still considering intervening in this lawsuit, but we'll wait to see what the result of that negotiation looks like. But that's the current status. There are investors who are very concerned that the length of time that their money now must be invested is going to be on the longer side, and nobody wants that. People want the flexibility of being able to pull their money out, as soon as they're able to. I want to make that clear. It's not like, there's a narrative out there that people have, that people will get into, that investors will be incentivized to invest in short-term risky deals. I kind of push against that, because I believe that people that have $800,000 are usually fairly sophisticated and can understand, and can judge the merits of a deal. And even if they're not able to, again, it's a free market. But again, this is a real concern that investors have, which is that if I've invested in, say, a 3-year project or a 4-year project right now, based on the results of this lawsuit, my money won't come back to me in 3 or 4 years. My regional center may have to then reinvest or redeploy that money into another project, locking it in for an X number of years, who knows for how long, into another deal that I haven't even done my diligence on, like I did with the first one. So that's, I think, would summarize, I think, where we all stand.
I think that's it. That's it. I have some technical thoughts, but I think I would love to, let's get some questions. I want to address, the specific questions that folks have. So go ahead and pick the ones that you think.
Just a lot of people asking. Well, there are people saying that AIUSA should withdraw the lawsuit. I will say that neither Carolyn or nor I are on the board of directors of AIUSA, so that decision is definitely not in our hands. But you should. A
lot of folks are saying that. Maybe I can kind of interject here with some technical notes. So Ishaan mentioned that the lawsuit is kind of tilting in the plaintiff's favor, the regional center's favor. Now, I think that, and there's a settlement that that could be advancing even later this week. So the legal argument, there were many kind of sort of like, we don't like this kinds of arguments or points made in the complaint. But the sole legal argument, as far as I can discern, is that this position, this service interpretation, was advanced without rulemaking, and that it should have followed formal notice and comment procedures under the Administrative Procedures Act, or the APA. And so now, what would this settlement look like? Well, it could look like, well, okay, you're right, we shoulda, or we will. This is the agency that might be speaking, and we will engage in rulemaking. And so that's what could be the outcome in terms of the next steps. And so could we have a rule that reiterates the October 11, 2024 service position? The answer is yes. Or I'm sorry, 2023, wasn't it? The answer is yes. So we could have rulemaking, and that could be the victory for the plaintiffs, which would result in rulemaking that essentially at the end of the day could get us in the same position. So I think that, like our prior discussion, the story remains to be fully penned at this point. And it may not be what folks kind of envision as the industry win, or the regional center side win. So I think we need to stay tuned.
Right. So I think Bharati asked a question, which is, she's a new EB-5 investor, and says that, there was one thing stacked against EB-5 investors, which was this lawsuit. Now I see there are two things stacked against us, causing a lot more anxiety and potentially making it.
Can we address that? So, yeah, because, and maybe this is the mother in me, I'm not sure, and it's a good thing. Mothers are good. Investors, I think it would, I haven't encountered in our kind of social circle, if you will, within our industry, right? Within the community of advocates across the board, at least that I, have spent significant time with, who don't care profoundly about investors. How could you not? First of all, from a very practical level, your bread and butter, from a material standpoint. And then to the other end, I mean, we're talking about like the highest, most, noble human feelings. I mean, not a monopoly on them, but we're talking about these aspirations, and a desire for something more, something better, for freedom, for opportunity, particularly for your children. I mean, unless one is, I don't know, most of us are aligned. And I think that's really, really important. We're going to have disagreements. And I do believe that that's a healthy sign. It's a sign of maturity in a community, and it's about how we resolve it, right? But in terms of protection, protecting the investors, caring profoundly about the investors, I hope I speak for everyone. We do. We really, really do. And, thanks to AIIA, there's also, a voice, right? If there are things that the investor community is critical of, it's not the end of the world. That's what should happen. We should have discourse. We should have discussion. We should have disagreements. And so it's about engagement, I think, in a productive way.
Yeah, I agree with that. If there are EB-5 investors who truly are distressed, I mean, feel free to reach out to us, our nonprofit. We are pretty active in this space. If there's initiatives that investors want to take on that they feel is important to them, absolutely. We have a concentrated group of folks that are very interested in the sustainment period lawsuit, and we've raised money for a lawyer to actually be involved in the case. And speaking of investors and again, the future and caring about them, I want to answer a question that Durgesh put forward, which is, and this is something that I really want to use this platform to sort of answer, which is that in case the regional center program is not extended, why would any regional center continue to carry out the administrative work at huge cost for existing investors only when no further business is coming in? So this is the worst case scenario. If the program doesn't come back and there's no new investors coming in, why will regional centers continue to do the business that they do?
Well, first of all, it's the right thing to do, right? And secondly, there's a program and compliance, and then there are other obligations, including the obligations of the manager in the operating agreement or the partnership agreement of the new commercial enterprise, of which you are a member or a partner. So there are contractual obligations, and then there are also principles of fiduciary obligations that underlie those contractual obligations as well. So your investors should not be, left kind of in limbo or sort of untethered if the program, in the worst case scenario, if the program is not reauthorized, and it never is, which won't happen.
Well, I mean, look, even if the worst case was to happen, which, if it doesn't get reauthorized, I will say this, and I think this is really important for investors to hear, that EB-5 is not a Ponzi scheme. No regional center, no investment issuer should rely on repaying their current investors with new investors. Even if there are no new investors coming in, the way a regional center investment issuer is structured or structures their investments is for them to keep earning money. It is their obligation, as Carolyn said, and as it is a duty as a fiduciary to do the right thing, to ensure the accounting records, the 8 to 9 templates, all of that stuff is prepared years into the future, even as you go through your investment. That is the obligation as a fund manager. So to be clear again, even if there are no new investors coming in through the door, any program, any project which has been structured correctly, any regional centers which functions the right way, the ethical way, will be in a position to comply with the program or whatever's left of it, and repay your investment fund as and when they are supposed to.
I just want to say two things. Number one, what Ishaan and I are talking about is what should happen. And so that isn't to say, assume that it will, right? Every investor should be actively participating in doing your research, doing your diligence, even after your investment, right? Staying in touch, communicating, staying alert, learning. So that's not to absolve the investor community of that. That's for your protection. And then the second thing is, I say it's not going to happen. The program is not going to be terminated. I am saying that not as like any kind of, like do nothing, it'll be fine. No, it's another very important thing that we all have to get involved in and to make sure that doesn't happen. And I feel confident that we will. That's what I'm trying to say. Respectful of people's times, and yours, Ishaan. Thank you so much for hopping onto
Sure.
this.
Can
And
we answer one more question
all
that
right,
Jeff
go for it, Matt.
asked? Yeah, so Jeff from Civitas asked a really good question, and this is really good. How can EB-5 stakeholders, regional centers, investors, attorneys, etc., together seize on getting the positives mentioned by Trump and the secretary, like for example, the 1 million visas and like all the good stuff about it, and not the negative things like paying off the deficit, the 5 million investment amount, and being structured as a payment rather than an investment? What's the strategy?
That's such a great question. I mean, first of all, those would be great. I mean, I like, who doesn't want to reduce the national debt? Like, that would be fantastic. So I think it's about emphasizing the positives in what we know. What we know is EB-5 and what it does. And I would say keep it concrete. We can talk about the thousands and thousands of jobs and the billions and billions. Yes, that should absolutely be a part of our narrative. But let's speak to what we know. What about your project in your community, and the folks in your community who appreciate what it's brought, what it has enabled? I think that's what we should speak to, because we all have those experiences. We have incredible experiences of investor clients who are grateful, who are able to work, and in whatever field not work, realize their goals, have very flexible opportunities because of EB-5, and in particular because of concurrent adjustment, right? So there are many, many, many examples. I would stick to the concrete ones, that that speak to you in your heart personally, and do everything you can to get them out. Use your channels. We all have them.
Yeah, I agree with that. I think it's also important that, like, and echoing what I said earlier, which is we all got to work together. Pitting pitting stakeholders against each other, things like that is definitely not going to help. And I think, it's more important than ever before that we as a community, like, work together, which includes, everyone from the stakeholder at the lowest rung of the ladder to the highest ones. It can't, making decisions which only benefit a certain group will not end well. I'll even give an example of pitting investor groups against each other. I mean, there is a community of pre-RI investors that feel very bitter about this post-RI program. Just think about the set-aside visa program, set-aside visas. There is 100% pool of visas that was supposed to go to someone who invested in 2018 or 2019. And now 30% of that allocation is now going towards new investors, allowing those investors to skip the line. That's not very fair to those past investors. And that bitterness that gets created, that hatred towards the people in charge, is not good for anyone. And we really have to kind of reflect on that as an industry if we're going to want this program to stick around for the long term.
Thank you for that, Ishaan, and thank you to AIIA. The website is goaiia.org for the advocacy and for being a voice of advocacy for investors. Appreciate that.
Thanks for having me.
Thank you, everyone, for joining us, and stay tuned. Lots more to come.